Hello everyone. It's really glad to see everyone here today. So my name is Meto Selden and I am your moderator today with Mr. Patrick Kofi Benyon. And today's event is titled Intergenerational Equity in Ocean Governance, Securing the Rights of Future Generations. We will be hearing a variety of discussions and bring about a meaningful collaboration between World Youth for Climate Justice, WYCJ, and African Young Leaders Foundation, AYLF. WYCJ is a global campaign that took climate change and human rights to the International Court of Justice. It was to get an advisory opinion. The advisory opinion seeks to clarify the obligations of states to protect the rights of the current and future generations from the adverse effects of climate change. And as for African Young Leaders Foundation, it is an international non-profit and non-governmental organization in Ghana with branches across Africa. AYLF is run by and for esteemed young individuals who have held several leadership positions internationally and with the desire of devoting themselves as agents of change and source of inspiration by pulling their resources and time together to train the next generation of African leaders. They seek to engage in humanitarianism by securing scholarships, educational funds, and bursaries to the brilliant but needy individuals. Both of the inspirational youth groups have come together today to spotlight youth voices in ocean governance from Africa and across the world. However, the host WICJ as of today is mainly from Asia. Yes, Mr. Kofi, do you have anything to say?
Thank you so much for the introduction, and that was quite brief, and also you were able to articulate everything about AYLF. To add something more, AYLF is also not solely or entirely oriented in the Pan-African values, but we value that value, and therefore we add it to our programs and activities. We ensure that everything is rooted in Pan-Africanism, and beside that, ways that we also try to mobilize and train people includes having activities like this, dialogue sessions, trainings, and so on and so forth to bring about different changes in the community. So we are so happy to be here today, and thank you for the introduction. We look forward for an insightful discussion. Thank you.
Thank you so much for the additional information that really helps to add and shed light to what AYLF does. So both of the youth groups today have come together with this meaningful collaboration to spotlight youth voices in ocean governance across the world. So we are at a critical phase where triple planetary crisis is existent. So we have climate change, biodiversity loss, and toxic pollution, all of which threatens our ocean, which covers 70% of the Earth and is vital for climate regulation and life. The ocean absorbs 90% of excess heat from greenhouse gases, but is now suffering from warming, acidification, and pollution, which impacts marine life and millions of people dependent on it. Offshore oil and gas extraction remains a major driver of ocean harm, and phasing it out is significantly essential to meet global climate and ocean goals. Moreover, the recent advisory opinions by the International Court of Justice marks a historic milestone, affirming every state's legal duties to protect the environment and human rights, including those for the future generations. This is a unique opportunity to enshrine intergenerational rights in law, ensuring that the ocean's health is preserved for those yet to come. The webinar today, which is a side event for United Nations Ocean Conference, is co-hosted by France and Costa Rica, so it calls for an urgency to take action in transitioning to fossil-free ocean and safeguard marine biodiversity. As youth leaders, we urge all stakeholders to seize this moment to turn commitments into binding actions that protect our planet and the future. Together, let's turn the tide for a healthy ocean and a sustainable future. Now, let's come together and engage in a dialogue to commit ourselves to ocean governance. Today, with us, we have 6 esteemed speakers from a range of backgrounds, namely, they are policy experts, grassroots, and community leaders, so as to ensure a multi-sectoral and intergenerational discussion today. I would personally also like to thank all of the panelists for taking their time and effort to make a difference with everyone present here today, despite various time constraints. So with this, I would like to first invite Dr. Justin Sobian. Although it is very late for him, he has agreed to the invitation given the importance of the discussion today. So we are very grateful for your kind consideration. So without further ado, Dr. Justin is an international environmental lawyer from Trinidad and Tobago. He is currently a senior tutor at the Auckland Law School and acted as co-counsel for Grenada and St. Vincent and Grenadines at the historic ICJ advisory proceedings on climate change just last December. To ask the first question to Dr. Justin, given the International Tribunal for the Law of Sea's advisory opinion emphasizing on states' obligations to protect the marine environment, how can legal frameworks be strengthened to ensure intergenerational equity is explicitly integrated in ocean governance, particularly for vulnerable small island states? So, Dr. Justin, if you would kindly answer the question.
Yes. Thank you very much for your introduction and for being here, of course, with my esteemed colleagues. And you're right, it is nighttime here in New Zealand, but I'm happy to be here. So I want to speak a little bit about, as the topic says, intergenerational equity and ocean governance. And of course, we'll speak about the ICJ as well. Now, in the first advisory opinion, the advisory opinion that came before the ICJ, we were speaking about ITLOS. The first question, the first issue that really dealt with that particular case was the issue with respect to, the one I would really like to zero in on was with respect to section 192 of UNCLOS, United Nations Convention on the Law of the Sea. And that particular section gave out a general obligation for states to protect and preserve the marine environment. Now countries like Bangladesh, Micronesia, I think COSIS as well, they argued that general obligation is two things. It has a positive obligation and a negative obligation. The positive obligation is that states should take active measures to protect and preserve the marine environment. And the negative obligation is that same states should not do anything to degrade the marine environment. And when you look at it, they looked at, ITLOS said that was an open-ended obligation, which can be invoked to combat the degradation of the marine environment, especially with respect to climate change, ocean warming, ocean acidification, sea level rise. And the main thing why we have to protect, why they recognize that open-ended general obligation to protect the marine environment was for the future, to prevent future harm. So in other words, to protect, to preserve the marine environment for future generations. That being said, so that was just one aspect of the ITLOS case that touched upon protecting the marine environment from future harm, which included future generations. But when it went to the ICJ, because of the legal question itself, they really expanded on that whole principle of protecting natural spaces, marine environment, or the environment, or in this case, the climate system for future generations. So just the legal question itself, the part B, it said that what are the legal consequences if states fail to perform their or carry out their obligations to peoples, which of course can mean indigenous persons, individuals, and present and future generations. So I've said this over and over at numerous webinars and also at the ICJ representing Grenada and St. Vincent and the Grenadines. Who are future generations, right? Now, the simplistic view is that some people say future generations is my 2-year-old son or my 3-year-old daughter. They will be the future generations. But in international law, it's not so. Future generations are persons who are not born as yet. So future generations would be, for example, if you have somebody who is going to be born in 2030, or let's even go further back, 2050. So what we're trying to say is, why should international law protect these abstract group of persons who are not even born yet? Or why should states have obligations to an abstract group of persons who are not born yet? The Pacific community said it straight. I think it was the director for the Pacific Island Students Fighting Climate Change, as Vishal. He said that there's nothing abstract about rights about when it comes to the climate crisis. That was one statement that one quote that he made, and he's quite right. So the thing is, why should an international court, let's say the International Court of Justice, why should they be concerned about an abstract group of persons who are not yet born? That whole idea, the crux of that idea, lies on the principle of intergenerational equity. Intergenerational equity really means that the present generation holds the earth, the environment, in this case, the ICJ, the climate system, the marine environment for ITLOS. They hold all these natural spaces for the benefit of they hold these natural spaces for the benefit of future generations. So in other words, each generation is entitled to inherit a planet at least as good as the previous generation. At least. So in other words, the present generation must pass on to the future generation at the minimum level, the same level or the same entitlement that they had the particular planet at the same level, minimum. So in other words, of course, it's our duty to try to pass on a better planet to future generations, but it should be at a minimum as the same that the previous generation has received it. That is the whole principle of intergenerational equity. The reason for that principle is that the future generations, they did not consent to the climate crisis, and they should not be unduly burdened by a crisis which they have not consented to, all right? So that is the whole thing about the intergenerational equity and why the rationale as to why international law should take that into consideration. Now, the next step that the courts have to grapple with is that who is going to speak for future generations? Because future generations could not appear before the ICJ. They could not appear before ITLOS. They cannot appear before the Inter-American Court of Human Rights. So who's going to speak for them? In my opinion, since future generations cannot be heard, it is the Pacific Island Students Fighting Climate Change and the World Youth for Climate Justice. They are the perfect examples. They are closest in nexus to the future generations, and they have the moral authority to demand that not one more ton be polluted or be pushed into the harmful greenhouse gases, be emitted into the atmosphere. So it's similarly within the youth's prerogative to say no more to fossil capitalism. Now, these are the type of arguments that we in the Caribbean, in Grenada, we have put forth towards the International Court of Justice. How can we then, the question is, how can we as advocates, lawyers, policymakers, but let's say the court, international lawyers, how can we represent future generations? All right, because as I said, some global north countries said these are abstract a class or group of persons who don't exist. But how can we in international law represent future generations? As I said, the ICJ case, the ICJ advisory opinion, that started as a grassroots movement with the Youth Pacific Island Students, WYCJ. in law, the best way that we can protect future generations is for states or the present generation to act as trustees for the climate system, the marine environment, or the environment per se. Because if we act as trustees, we can pass on, we can safeguard the climate system for the present and the future generations to come. So in other words, we hold the earth, we hold the environment in trust for future generations, not for ourselves. It's a very altruistic job, right? It is not for ourselves. We hold in the earth and the climate system for the benefit of future generations. And this is what we call the attitude of gratitude. The attitude of gratitude is because future generations have received a planet that is better than, or even at the same level at minimum that the previous generation had, they will have an attitude of gratitude to do the same for their children or their children's children. It is like, for example, if you are young and you have no, you're a student or you have no money or you don't have a job as yet, and you don't have a vehicle. So you spend your teenage life hitchhiking for drops, where it is you want to go to the country, you want to go to the beach, you want to go to town. Someone stops for you and they take you to your destination. When you get older, you would then, when you have enough money, you saved enough to buy your own car, you have a nice job, and you see someone else hitchhiking, you would more than likely stop for that person because you would remember what they did in the past. So it's the same thing here for intergenerational equity, is the attitude of gratitude. Once you pass on the earth for future generations, the future generation will then pass on the earth in a better way, in a better standard, and a better quality because of that whole attitude of gratitude which they received. And the whole principle of intergenerational equity is accepted already in international law. We have seen it in the nuclear weapons case, advisory opinion, another advisory opinion, where the court had, and I'll quote this, the court said that the environment represents the living space. Now, this is a quote, the living space, the quality of life, and the very health of human beings, including generations unborn. So the courts has already accepted intergenerational equity. They have already accepted that we have the whole environment in trust for the generations unborn. Same thing with pulp mills, where Judge Trinidad said it can hardly be doubted that the acknowledgement of intergenerational equity forms part of conventional wisdom of international environmental law. So it's there. So I think I would just leave it there for now. I know we had 8 minutes, so thank you very much. And I look forward to the questions later. Thank you.
You were pretty much good on time, Dr. Justin, and thank you very much for such an insightful answer. So this definitely gives us a new lens to look at ocean governance and also securing the rights of the future generations. So with this, I would now hand over to my co-moderator, Mr. Kofi.
Thank you so much. Thank you so much, Ms. Minto, and also thank you, Dr. Justin, for the insightful presentation. I think I have learned a lot, and I believe that all the viewers and listeners to have gotten a lot of insight. So proceeding to the next speaker is Stephanie Ejram Akpoma, who is a Ghanaian, and Ms. Stephanie is also to read her short bio. She is an expert in sustainability and environmental law with a strong focus on climate policy aligned with international frameworks. Her work blends legal expertise with strategic action, particularly in areas like corporate sustainability, the circular economy, and green job creation. Ms. Stephanie has played a key role in shaping major initiatives, including the British Council, Green Stronger Together for Climate Program, and the African Development Bank Youth Climate Council Framework, which she contributed during COP27. Ms. Stephanie, based on your leadership in such framework, we would like to also hear from you what critical mechanism must be established or strengthened to empower young people to actively participate in implementing the principle of intergenerational equity in ocean and law policy in Africa. Please, you are welcome to take the floor. Thank you.
Thank you very much for having me, and Kofi, thank you for that introduction. Dr. Sobion, that was a very nice introduction, and I'll continue from where you stopped to you led me. So particularly for young people, what I've seen happen when it comes to international frameworks and the ITLOS generally, is that our active participation depends particularly on our pool ourselves. So there are two factors to it. There's a part where we're asking an external person to empower so that we're able to partake and implement these policies by ourselves. And another part where we have to take it from outside. So young people have to pull from outside, while the external world, the governance, the ICJ, the likes of principal actors, particularly state actors, national actors, we should pull from that side. So we have to push from here, and then they pull from that side. What I've seen is there's more often we are expecting them to give us the opportunities. But in my line of work, I have taken more than I've asked permission for. And once I have done that, I have seen that people have responded. When you keep knocking a door, a number of things would happen. Either the door breaks down, they'll ask you to leave, or they would respond. So when we push at young people, first and foremost, it is likely that something would happen. But when it comes to the national and state actors, first and foremost, we have to make sure that a lot of the policies are integrated in our frameworks. We systemize some things. We intentionally create advisory opportunities for young people. So in other parts of the climate crisis, which has nothing to do with the ocean, we've seen that a lot of advisory boards have been created for the UN to advise them on stuff like that. That is an intentional initiative to put young people in particular positions they would ordinarily not be in. There's also a lot of things that we have to look when it comes to strengthening regional and legal corporations for marine protections on the local level nationally, by implementing some of these things as active participations in a lot of the policies and legal frameworks that we have. So we see what happens a lot with young people is that we don't see them taking active roles, or young people don't take very active roles in trying to be part of national policy, national leadership policy. And there are lots of barriers, we know that. There are lots of barriers that we see, systemic barriers that we see. So our duty is to push from one side in terms of making sure that our advocacy is pointed at the things that we want to do. But the frameworks, including putting out very nationally international frameworks at the national level, should be actively taking place. Mato, back to you.
So much for the response. I think that was great, and we will get back to you with questions, and we encourage also the participants, if they have any question, they can leave it in the chat box, and we will get back to them. So I'll hand the floor to my co-moderator, Ms. Mito.
Well, I really apologize for sending the message to everyone. So to move on, I would like to now invite our next speaker. So we have Ms. Johanna Guzman. So she is a senior lawyer with the Center for International Environmental Law with over a decade of experience in international law and human rights. Previously, she served as a regional advisor on human rights and social development with the Pacific community, where she worked closely with Pacific governments in coordination and preparation for the ICJ advisory opinion on obligations of states in respect of climate change. She also served as counsel for both the organization and the state of Kiribati. To ask her the question, so drawing from your experience advising Pacific governments and your work on the ICJ advisory opinion regarding climate change, what legal or policy mechanisms do you see as most effective for embedding intergenerational equity into ocean governance frameworks? How can states ensure that the rights and interests of future generations are not only recognized, but also enforceable in practice, especially in regions most vulnerable to climate impacts?
Thank you so much. Yeah, thank you so much for that introduction. And it's really an honor to be a part of this panel and lots of friendly faces on this Zoom. First, I just want to say thank you for putting this together. It's really wonderful, and sending extra love to those making their way out to Nice and out to France right now. I also want to say congratulations to the work that's been done. I know some people on this and widely for the African Court on Human Rights and or Human and People's Rights with their latest advisory opinion. I think it's really exciting turn of events, and hopefully, we can impart what we've learned in the various forms from, the Tribunal on the Law of the Sea, the Inter-American Court, as well as the ICJ. I do really appreciate this question because I think I'm going to answer it with some background stories and information of what we learned going forward with the ICJ, because, when we're talking about ocean governance and we're talking about the protections that need to be put and implemented to protect our beautiful blue oceans, there is a lot that can be done and learned from, and spaces to create and be creative in the lawyering to get actual representation and put youth in positions of power and decision making that needs to happen. From the ICJ experience, one of the things that I think the Pacific did particularly well was really from the get-go, it was always about the inclusion of youth, and Pacific governments in particular really should be praised for really ensuring that from the moment that we started doing the right shops that we created to assist governments in their submissions, all the way through to the speaker shops that we had to prepare for those oral hearings. Pacific Island students fighting climate change and Fishall in particular were co-partners in this whole process. It wasn't, oh, last minute, let's get them to sit on and talk about this wonderful thing, an idea that they came up with in their law school class in 2019, and then sit down and shut up and don't speak anymore. This was about ensuring that the youth vision, the necessary moral authority, not only that they had, but also actual legal participation in this, that we ensured both Cynthia and Bashal that folks could get up in front of those 15 judges and speak. And, of all of the lawyers that got before the court and lots of beautiful things said and some not so beautiful things said, things that left the judges, things that made, the front pages and news, it was the youth standing before the court, claiming the power and knowing what needed to be said, so that there was actual recognition in this way that future generations, those yet born, present generations that are included in the question itself, are actually a part of the problem solving that needs to happen. In this way, with UNOC and the ocean governance frameworks, it's governance like anything else. Where you can start and include the right people right from the beginning, the better the chances you are that the outcomes will be transformative. We've seen this happen a lot in many spaces, from in the Committee on the Rights of the Child, with the representation from across the world, from starting with youth plaintiffs before the committee, requesting that the inaction of their governments be brought forward and remedied. And while we didn't see the most transformative outcome we were hoping for, it did lead to the General Comment 26 from the committee that I always point to, because one of the things that it calls for is transformative and novel forms of remedy to be encouraged. And one of those things was the orders to establish intergenerational committees in which youth are the active participants, right? Not just a name on a page and a check on the box, but an active participant in the determination and overseeing of proper implementation measures that mitigate and adapt to the actual crisis we have at hand. I, since working with the ICJ, stepped into the space of fossil fuel non-proliferation, knowing that after the experience at the ICJ and working closely with the governments that are at the cutting edge and calling for those biggest changes in these UN systems, that the next big challenge and the next big thing is to ensure that we have corporate accountability for the driver of climate change itself, the fossil fuel industries and whatnot. And luckily in that space, you get to work with a lot of those representing future generations, youth, advocates, etc., knowing that you have to speak truth to power and we have to take on this next big thing. And so I'm really, really thrilled with how the Pacific and other regions are taking on ocean governance and ensuring that our oceans are fossil free, ensuring that our oceans are protected in the right ways, especially in following the ITLOS advisory opinion that really did call for, despite any jurisdictions that where there's pollution and point source pollution, that it matters, that it is absolutely regulated with the due diligence and the standard that is required to rise to the level of the threat that we face with climate change. And a lot of that really did involve folks on the ground in the countries, in their own countries, pushing their governments to rise to the climate ambitions that need to exist. I really do applaud the movement. Thank you all for having this panel. Continue to, just like my fellow panelists have said, continue to push because it's necessary, and know who your allies are, because this is the moment that we're forming how ocean governance will continue to move forward, and we need you there as part of the fight. Thank you so much.
Thank you so much. That was a really wonderfully put answer. So after having you share with us that the Pacific youth voices were being taken into consideration, it gives us the hope and this light that our voices will also be taken into consideration in the future. So really thank you, and also for joining really earlier. So that was also a really appreciative. So I'd like to now invite Ms. Aditi. So to briefly introduce Ms. Aditi, so she works as a researcher at the British Institute of International and Comparative Law, and she also leads the Legal Advocacy Task Force for World Youth for Climate Justice. Her work is anchored in tackling climate injustice through a decolonial lens, ensuring that her advocacy in environmental and climate law advances rights-based, equitable, and inclusive outcomes. So to ask her the question, since your work emphasizes strategic litigation and decolonial approach to climate and environmental law, with the ICJ and ITLOS and Inter-American Court of Human Rights advisory opinions bringing renewed attention to states' obligations toward future generations, how can legal strategies in ocean governance address both historical injustices and current inequities? Handing over to Ms. Aditi.
Thank you. Thank you so much. Also, thank you so much for having me and for the great introduction. It is not going to be easy to follow with what Justin, Stephanie, and Joanna have said, but I'm gonna try. Also because they're legal experts. So yeah, in terms of the ICJ advisory opinion and the Inter-American Court one and the ITLOS that's already delivered, and then the African Court that's forthcoming, I think it signifies a very collective and a very important shift generally in international law. And this the ITLOS has already come out, and it hopefully bearing that as a standard for the ICJ, for the Inter-American Court, and the African Court advisory opinion. It affirms certain binding standards, certain binding obligations that not only are towards the environment, but also apply to the people, to the territories, and future generations. And this was largely, as Justin and Joanna also pointed out, was argued before the court, before the ICJ, and even before the Inter-American Court. Again, it was emphasized by all the parties that participated in it. So I think that's very significant. So generally what these AOs or the general or the common hope that we have is that these advisory opinions will inform at least three important things for advocacy and for legal tactics, strategic litigation at various levels, like be it international, regional, or even domestic. They will First is it is a platform, or it is like a plethora for evolving legal standards from a very historical perspective. Again, as Justin pointed out, a lot of arguments, even the questions, the way they were framed, the way the preamble, the chapeau paragraph of the preamble the resolution is framed. It looks at historical perspectives, which essentially is setting legal standards in international law, because it has been very difficult to look at, like, for international law to look at it retrospectively, especially from a climate change and human rights intersection perspective. Secondly, principles like intergenerational equity and its tangible usage is going to be very useful in practical legal strategies. And this means at national level, it could be through litigation, which usually is the last resort, but before that, also through national and regional policy making, which I think certain standards set in law, which are clarified, which the court will clarify, which the ITLOS has already clarified. For example, like, marine pollution, Article 192 that of the UNCLOS that Justin mentioned, and like how marine pollution or GHG emissions is considered as marine pollution. Though these kind of standards will help the tangible, users of these principles in regional and national policy spaces. And then thirdly, I think, which also is very important, and Joanna highlighted it very eloquently, is the frontline community's agency over this while doing this or setting the standard in the process. So as Joanna said, that, PFCC has been at the center of this since the beginning. They have been partners and co-leaders with the Pacific governments that brought this whole thing to the UN and then to the court. And then the role of World Youth for Climate Justice and supporting all that, I think that shift, or that has given agency to frontline communities for future generations, or, as Justin said, the people that hold the closest nexus to future generations. So I think that's very important. This also is a way of looking at it from a very post-colonial perspective, because it's not news that generally these kind of processes, international processes, and generally international law is essentially very Westphalian in nature in many ways, and there are various perspectives that need to shift that. So I think these three elements are the evolving are quite important and have marked a shift in how who participates in these procedures, how international law can be looked at, and how it can be evolved. To go a little bit into details of these three elements, is that the first one, which is evolving legal standards, as I mentioned, ITLOS has clarified the anthropogenic greenhouse gas emissions constitute as marine and marine pollution under the UNCLOS, and thereby states have obligations to reduce and to prevent and control such emissions. This again has come up a lot in the ICJ oral hearings, and we're hoping to say that there is some sort of a confirmation of what the ITLOS has said, which we're expecting, is that the ICJ then goes a little in the best case scenario. The ICJ would go a little bit to define the legal consequences of violating the obligations, very specifically in this case that the UNCLOS has under the UNCLOS that have been reaffirmed by the ITLOS, and also potentially looking at historical how to deal with historical emissions, and then the systemic inaction of this. This could be the best case scenario in many ways, to put it in a very easy language, but then also hoping that the Inter-American Court advisory opinion comes before the ICJ, which also we're hoping and is likely to happen, is that the Inter-American Court has gone further into these clarifying these obligations through its OC 17 advisory opinion in 2023, and then also now the La Oroya case that came out recently. So I think that also will help set the standard, or like affirm the standard, or like make it more foundational, more concrete. Um, and issues or contentions that were raised that some argued were very vague, like the recognition of the right to a healthy environment as a standalone human right. I think the Inter-American Court, hopefully, because it has such strong jurisprudence on it, would again affirm this in the climate change advisory opinion, which hopefully will help cement it in the ICJ advisory opinion, depending on how they come out. But generally, through arguments, the questions also that were asked by the judges, the third question, which talked about how to materialize the right to a healthy environment, I think those standards, the court thinking about that, the court trying to clarify that, to see what it already ensures. I think it would be great, or it would be again like the due diligence of the court to see how these standards have been set by other jurisprudence, domestic jurisprudence in a lot of global south litigation cases that have happened before. So the point of all of this is that, because environmental law and climate law has been looked at in various silos, and human rights law has been looked at, or has been fragmented and looked at in various silos. I think what these advisory opinions have another power of doing is to make sure that it is interpreted or read together in good faith of each other and harmoniously. So I think, all the advisory opinions, one after the other, have the power to cement that one by one. The African court, the petition has a lot of questions on the first question itself actually is on intergenerational equity, and looks at it from a very regional lens, which I think will also help cement policies, and also help a lot of countries, these regional groups, to come up in international negotiations and at an international platform like the UNOC or the other COPs, to come up with strong arguments that they can use, they can utilize to make sure that there is they get what they come for, all set in the law, all set not as moral standards, but also as authoritative legal standards. So I think this general holistic interpretation of international law, it can transcend certain procedural climate frameworks that are rooted in human rights, environmental law, the law of the sea, and also other customary principles in such as sovereignty, like permanent sovereignty over natural resources, in a very comprehensive way, and thus also allowing it to be bottom up, and then facilitating it for frontline communities and most vulnerable people. I think I have two more big points, but I think I'll stop here for now, because I probably am going overboard, and then I'm happy to take more questions or talk about this a little later.
Thank you so much for the wonderful answer. It was really insightful. So as for your points, I believe we have participants who will be asking questions, and you will be able to go through them once. So before we move on to the final speaker for the webinar today, so I would like to say that we have a Q&A session after this, so the participants can feel free to ask the panelists questions. So to move on, we have Ms. Leah Wyman. So she is a PhD researcher in the Faculty of Law at the University of Cambridge, specializing in international, environmental, and climate change law. Her research focuses on emerging ecocentric legal frameworks, including rights of nature and ecocide law. She is also co-lead of the Youth for Ecocide Law branch of Stop Ecocide International and has represented youth voices and legal solutions for change at major climate conferences. To ask her the question, with your leadership role in the Youth for Ecocide Law movement and your research on legal frameworks for environmental protection, how do you envision the criminalization of ecocide contributing to stronger intergenerational equity in ocean governance? How can recognizing ecocide as an international crime help safeguard the rights of future generations to a healthy marine environment? Handing over to Ms. Laya.
Thank you so much to the African Young Leaders Foundation and World Youth for Climate Justice for hosting this and for your leadership in advancing intergenerational equity and for, of course, the kind introduction right now. It's an honor and a privilege to speak as a final speaker today on behalf of Youth for Ecocide Law, but also a little bit in my capacity as legal researcher working on ecocentric legal developments and frameworks to strengthen environmental protection. So both from a youth-led advocacy and from a research perspective, I do believe that the criminalization of mass environmental destruction is a very important step towards the moral and legal protection of vital life-giving ecosystems, such as the ocean, for present and for future generations. And it's about restoring accountability to a system that has permitted destruction of these ecosystems for far too long without consequence. And this is particularly urgent in ocean governance because our ocean is not only a victim of environmental harm, but a critical ally in maintaining climate stability and ensuring the survival of future generations. Our ocean is in crisis, from acidification to coral bleaching to destructive trawling and planned deep sea mining. Marine ecosystems are being depleted at an unprecedented rate. The ocean spans a timeline and significance that I think for us as humans sometimes is beyond comprehension. Yet our current governance models prioritize short-term economic gain over long-term ecological integrity. And future generations will bear the burden of this degradation. So current systems have to look at what can we do to address this. Courts from Colombia to Germany to the UN Human Rights Committee are beginning to recognize the legal rights of future generations, and some of my previous speakers have already addressed that. However, I do also want to add that without binding obligations to prevent and criminalize mass environmental destructions, these rights, we want to avoid that these rights only remain symbolic. And this is a little bit where criminalization of ecocide comes in, serving as a legal, ethical, and preventive tool. So criminalizing ecocide is not about seeking retroactive legal justice for past harm, but about protecting nature for present and future generations. And the leading definition of ecocide by the independent expert panel that was convened by Stop Ecocide International in 2021 lays out that ecocide means unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So this is the proposed definition at an international level. And by recognizing ecocide at international level, we introduce legal framework that places serious environmental harm on the same level as crimes against peace and crimes against humanity, but really all of the most serious crimes that are recognized at the International Criminal Court in the Rome Statute. And the aim is to hold powerful actors accountable for action that cause irreversible damage to ecosystems, including those that maintain healthy ocean ecosystems. And it's about closing legal gaps and holding individuals accountable, because at the ICC level, at the International Criminal Court, the action goes towards it's about individual actors. So it's really about pointing out like who are the key actors behind this and making sure that they can't hide behind behind parameters. I mean, and it also aligning and strengthening the trend of recognizing that the rights of future generations, this could act as sort of a legal shield that deters actions that violate these rights. It also integrates well within other frameworks, such as like the rights of nature, climate justice, and can amplify the force of international environmental law. So in short, where courts begin to recognize the rights of future generations, ecocide law could enforce those rights, both at a domestic and at an international level. And that elevates our collective responsibility to protect marine ecosystems, not only for present use, but also for the benefit of those that are not yet born. So recent court cases and also the advisory opinions, but let's look specifically at the court cases from like the Amazon court case of the Colombian Constitutional Court and also the German federal climate case. These are like establishing new legal baselines. And I think ecocide law kind of joins onto that trend of looking at we need new legal baselines, because we are introducing direct accountability for those whose actions destroy ecosystems on which future generations depend, and ensuring that the rights of the future are not just invoked in judgment, but are actively protected through criminal deterrence. And ecocide law is not just an aspiration, it's already becoming a reality around the world. Significant last year, the EU recognized crimes comparable to ecocide within its Environmental Crimes Directive. And this is currently being transposed directly from into the national laws of member states. And it's also an opportunity for national states to strengthen the criminalization of environmental protection and sort of to adapt their own legal systems to make that stronger. Earlier this year, the Council of Europe adopted a landmark treaty, the Convention on the Protection of the Environment through Criminal Law, which defines and criminalizes a wide range of environmental offenses and establish a legal framework for states to prosecute international conduct resulting in environmental disasters. So once that's ratified by members, the convention would become the first legally binding international treaty to criminalize severe and large-scale environmental destruction, so something comparable to ecocide. And we can also see this progressing within national legislation, and there are official proposals sort of in Scotland that you might have heard about, in Peru, Belgium, Brazil, Spain, Iceland, Turkey, many other countries really. But I think most significantly to mention right now today is also that last September, the island states of Vanuatu, Fiji, and Samoa officially proposed the crime of ecocide at the ICC working group. So discussions with member states are now underway, and also the Democratic Republic of Congo joined the Pacific Island nations by formally endorsing the creation of an international crime of ecocide. There's much more to be done, of course, and I'm sure many in the room, in the virtual room joining us here today, can also play an active role to help progress these efforts at various national and international levels. However, in conclusion, also let me add that ecocide law is not the silver bullet, and I think that's not what I'm proposing here. I think it goes along with what all of the solutions and things that we're talking about. However, it is a vital component in sort of the border transformation from exploration to conservation, from impunity to accountability. And if we're serious about achieving effective ocean governance that serves all generations, both present and future, then we must take the legal frameworks we choose to uphold very seriously. So to answer your question, yes, recognizing ecocide law as an international crime, but also at the national level, can help safeguard the rights of future generations to a healthy marine environment. Ecocide law is not just about punishing destruction, but it's also about preventing irreparable harm and shifting our legal systems from permissive silence to protective force. And it lends weight to the global recognition that the rights of future generations must be substantive, enforceable, and actionable. For youth, for ecocide law, this is a key part of our vision to shift public perception, and with that, our legal paradigm, so that ecological destruction is no longer business as usual, but a violation of justice across generations. Thank you very much, and I look forward to your questions.
Thank you so much. That was a really insightful answer, and also a new perspective to intergenerational equity from ecocide law.
Hello everybody from Abuja, Nigeria. My name is Anita Soina. I am a Kenyan climate change advocate and community development actor. I also identify as a digital SDGs and sustainability creator and influencer. I'm also the founder of Restoration Warriors Africa and the Soina Foundation that works with rural, marginalized and indigenous communities like mine to empower them for community and sustainable development. It's such an honor to be speaking in this event to a matter that I think is really close to my heart, based on the fact that I come from a community that is well known for preserving its culture, for having just values and practices that respect and manage our natural resources, our biodiversity, not just for us and not just for the people and the planet, but most importantly for the future generations. For a long time, this community has coexisted with wildlife. And I don't know if you guys are aware that I think I really have to throw this in, that it's only a Maasai who can be in the same environment with an elephant without actually getting scared or running from myths and without getting harmed. I'm sure most of you who've had a chance to visit Kenya's Masai Mara by any chance. I'm sure Dr. Olufonso, you've had a chance to be in Kenya for a long time, and you can bear me witness that the relationship between these communities, the Map people, the Samburus, the Maasais, with wildlife is something that is not just normal at the moment. I can say not many people are able to even understand that. How can you be in how can you coexist in the same land with such wild animals without actually having to fear or without having to harm them? So this concept of intergenerational equity, we can really see that it's deeply embedded in the traditional African society, and this is because there's also so much that has been part of the African culture that has just in one way or another contributed to preserving our natural resources, and also it's important to also note that there's the aspect of oral transfer of knowledge that has been taking place over the years, from our elders, how our elders were able to transfer knowledge to teach the younger ones and to pass on these cultural practices, these teachings to the younger generations. For example, at the Soina Foundation, we organize intergenerational dialogues where we bring together up to 4 generations, to have a discussion on things surrounding climate action, resilience, education, water, and so many things, to understand what has changed, how has it been, but what solutions existed that our communities had to use, what are these things that they had to discover along the way as they continue to face these changes? How did they tackle different crises? And so I think it has been really, really important and educative, because it also brings attention to the youth, that then how can we not totally forget this kind of knowledge and try to integrate it with the modern technologies and solutions, so that we can bring them together. Because most of the times, or I can say, the indigenous and traditional knowledge is not given the respect that it deserves, and so that way it continues to get erased, because modernization, of course, globalization, all those things happening are making it hard for people to sit down and have the conversations that we used to have from way back. And I remember when we were holding our first intergenerational dialogue, one thing that stood out from the children, the elders, is that we really want to get back to doing this in our homes and just having these conversations. But you see, the reason is because we don't look at it as it's not fancy, so we don't give it the attention it deserves. But if we respect indigenous and traditional knowledge and speak about it positively and amplify its role in addressing various challenges, I think that way we are able to make the young people understand that technology, innovation, new ideas that are coming up are important, but we can integrate and we can borrow something from the indigenous and traditional knowledge. In many African societies, there's also this communal nature, of decision making, collective decision making, shared responsibilities and roles in management of different resources. And I think that's really also very important, and this is something that can be borrowed. The promotion of participatory governance, that which in African society emphasizes and brings out that communal decision making. So this should also be reflected in the global structures, where we have all the stakeholders, and especially the communities, the individuals, people that benefit from these resources, people, let's say, that live, for this case, people live around the ocean, people whose action in one way or another affect the oceans, people that are stewards, because most of the times we look at these people, the community around it, as just maybe victims or perpetrators of the wrongs, or maybe victims of the impacts, but we really do not look at them as greatest stakeholders that can be very important in shaping solutions. So there is need for such communities, and there is need for involvement of every individual, every stakeholder, and most importantly the local communities. It is important for the global governance structures to adopt these perspectives by prioritizing, solutions that, as much as there are some things that need to be met immediately, we also are able to do it without compromising, future generations. I'm so happy to have shared the little about what I think and my view on the traditional African practices and how it can be borrowed by the global governance structures in the oceans sector, and even just the climate sector in general. Thank you very much. It's a pleasure.
So we have multiple questions from the participants. So we have first question from Gunjan Soni. So I think Ms. Aditi can be answered. So if I read the question, so even though countries like India recognize the intergenerational equity principle, it lacks implementation. To what extent do you think that the advisory opinions will affect that perspective? What strategies can domestic lawyers adopt to improve the implementation of this principle using the advisory opinions? But if the other panelists have anything to add on, you're gladly allowed to do so.
Yeah, thank you. Thank you so much, Gunjan, and also Meto, to give the floor to me again. In very specifically in India's case, I think there are two parts of the question, or I would like to answer them in two parts. Answer the question in two parts. One is very specifically in India's case, or in other countries where intergenerational equity is recognized as a principle, there usually are enforceable consequences, or at least legal standards that need to be adhered to or looked at. For example, very specifically in India's case, when I think of intergenerational equity and its implementation, I immediately think about the Goa Foundation cases, which the cases basically were filed by a civil society organization or an NGO against cutting down molim forests in Goa, which are immensely biodiverse. They're almost deciduous to tropical rainforests in that part of the state. And it was going to be cut down for, I think, mining, and some part of it was for mining, and some part of it was for road construction and infrastructure development. However, in that very specific case, the Supreme Court of India instituted or constituted a committee which essentially looks at various methods of various procedures on how intergenerational equity should be implemented through environmental assessment impacts. So in an environmental assessment impact, they took aspects of social impact assessment and various standards of of the principle of intergenerational equity, which are very hyper local to that context, and then applied it. And then it thus, there was a decision of like, certain forests, like the Mollem forest in Goa's case, was protected, it's notified, and looking at the intergenerational impact assessment report, they gave the decision of like, not halting mining in that region, or not giving out new leases for the areas that have already been mined, and they need to be restored, and the damage needs to be restored. So this is one way of like using principles like intergenerational equity, which are, when we write about the law, when we write about it, it feels so intangible. But I think the same thing has been done in the La Oreo case, and I will not go into detail on that one because I'm not an expert in the Inter-American legal system, but there are many standards that have been put by the courts in a very domestic context. The Philippines has done that through Kalikasa, and they have done it very beautifully in a few cases, where they look at the social impact assessment, the environmental impact assessment, but also look at participation of communities. Unfortunately, in India's case, I would say that there are other laws which have too many loopholes. For example, the Forest Amendment Act that happened in 2003, which have now bifurcated forests into notified forests, and then other biodiverse zones. If they're not notified forests, they're not considered as forests. And then we have the Hyderabad case because of that. So those loopholes need to have a very bottom-up, hyper-local approach to being addressed at a parliamentary level. In terms of the AOs, if you look at the ITLOS advisory opinion, and I think Joanna or Justin, one of you guys also said it very beautifully, that it looks like Article 1, like explaining that GHG emissions, air pollution. It also goes a little further into the restorative aspect by saying that, whatever damage has been done needs to be restored. They need to be protected. The marine environment needs to be protected, but also the damage needs to be restored. So these kind of, these very, I wouldn't call them very tiny aspects from a legal or a law perspective, but these kind of arguments, these kind of clarifications by the advisory opinions in many such cases, for example, a right to a healthy environment at an international scale, at a negotiations level, I think the international court, having concretized that either based on the jurisprudence of other courts or through the arguments that have happened before the court and the questions that the court has asked to be clarified, I think that will help a lot of other strategic cases. For example, there is the case, like the RWE case versus Luya in Germany. I think it is a win-lose kind of situation. In one way, it didn't explore there were issues of causality, the causal nexus, but at the same time, it opened a Pandora's box or a can of worms in a way which says that individuals can stand before the court against corporations. So that in that specific jurisdiction, it gives locus standi to these kind of claims, which I think is very significant. And it's very significant for in that space because I think the regional courts or the domestic courts in historically polluting countries need to have that kind of approach. There needs to be a shift, and that shift and that push is happening through these multiple various balls that are rolling in litigation space, in the policy space, in the law, like the ocean governance space, in the climate change space, but also like at the UN level, at the international diplomacy space. So I think these things are very important when they interact with each other in a hyperlocal context, but also at the same time at an international context. I'm sorry, I took up a lot of time, but yeah, I'll give back the floor to Mito.
Thank you so much. That was a really wonderful answer to the question. So we have a specific question for Ms. Stephanie from one of the participants. So, what strategies and partnerships are most effective for youth-led plastic recovery projects within a circular economy framework while ensuring there is sustainability? So, handing over to Ms. Stephanie.
Can you repeat the question? I didn't hear that.
Okay, so what strategies and partnerships are most effective for youth-led plastic recovery projects within a circular economy framework while ensuring there is sustainability?
Okay. Okay, particularly for youth-led ecosystem recovery for plastic pollution to ensure sustainability. Some very important strategies would be governmental participation and partnerships and local participation with the private sector. And I think that a lot of times when we talk about international frameworks, we don't see how we position them with private sector actors, including private sector law firms, private sector institutions that are actually responsible for the pollutions. The kind of strategies that will be very important, stemming from the international frameworks you're talking about, down to the particular persons that are responsible for the pollutions, would be being able to partner the persons involved in this. So if you take a normal youth-led organization that wants to be functional, that wants to be practical, a number of things come to mind. They're looking to see how are they getting funded to be able to partner with the right people. Who are the particular people that they're partnering? Particularly in Africa, we look a lot at institutions that are responsible for domestic financing. So we look at persons that are responsible for financing, including DFIs. We look at local agencies like the UN, the likes of international non-governmental state actors. We have one very important people to partner, the private sector actors who are responsible for pollution, and the second group of persons to partner. And another group of persons to partner would be regional or regional sector influences, that persons that are influencing policy, including national policy, regional policy, and state actors. And I also like to touch a bit on the kind of practical ways that we can integrate intergenerational equity into some of our national and ocean governance responsibilities across the continent. We all know that Africa will have the largest population by 2050. The population is likely to double. That population is going to be very youthful. What we are seeing happen is that after we have the frameworks are the notable frameworks like the ITLOS have been put out and opinions have been stated, the problem and the challenge becomes that it's a practical implementation on the national and international levels, particularly regional levels, that affects the individual person. And every time I talk about matters around these, I also talk about the practicality of those implementations. A lot of the time that we look at the policy frameworks and they remain policy, they do not hit the local level. So a number of things I'll state that needs to be categorically done would be to embed some of these intergenerational equity into domestic ocean law and climate policy locally. We need to amend local marine environmental laws to include language that represent duties of future generations. And I remember the doctor mentioning earlier on, Justin mentioning that the future generations are persons that are not here yet, and the persons that are closest to them are the best persons to represent them. I'll go a step further to say that the persons that are closest to them are even those who feel for them. So include persons that already deal with these matters locally, because when we limit it to persons that, yes, it's great for persons that are closest to them to represent them, but when we limit it to that, the persons that are decision makers in these, when it comes to these matters, are excluded from that kind of responsibility. And so we need to also focus on persons that are in the decision-making position that may not necessarily be close or be part of the youth, but are very actively involved in making decisions around them. It's also important that the ITLOS opinion is used to justify precautionary approaches in licensing, marine and spatial planning, because in framing some of these environmental obligations, we need to make them legal obligations on the regional and local level. When they are not legal obligation on the regional and local level, their implementation are a matter of whether somebody likes it or not. And I'm always insistent on private sector actors, because a large percentage of persons that pollute marine environments in and across the continent of Africa are private sector actors. Certainly private sector actors, including those who produce the whole value chain of fossil fuel. So from our offshore, onshore drilling to all our critical minerals. So it's particularly important that they become legal obligations for us and make them long-term impact. I heard one of the actors talk about environmental impact assessments, and one of the very most important things that we have to talk about when it comes to environmental impact assessment is that in partnering some of these private sector actors, what we as lawyers do, particularly in private sector practice, is to make sure that our quota part of doing human rights due diligence and environmental impact assessments for some of these mining organizations, some of these polluting organizations, is key, because that is one of the key national already existing policy frameworks across most countries. So most countries have their environmental protection agencies requiring the environmental impact assessments that go across the mining. And if you're very familiar with the context of Africa, what you know is that there's a lot of natural resource extractions that affect the marine life, that affect marine pollution, and how we're able to see them through. So the recent cases in the Ghanaian courts, for instance, on the Arusha Ghana cases and some of the mining licenses that has been given by the government of Ghana across board, what you see has happened is that young people are leading some of these initiatives to take very instrumental legislative action across the continent. And these are starting to show up. This has not been something that we are very familiar with, but these are starting to show up across board and across most African countries. And I'll give a lot of context in the Ghanaian environment because of that before I practice law here in Ghana. I would also have to mention that and I mentioned earlier when I was giving the introduction, I'm taking this opportunity and answering the question, but I'll mention earlier when I was doing the introduction that institutionalizing the mechanisms for intergenerational oversight is very important. The importance is that we need to require that national ocean governance bodies and international institutions include, one, future generational impact statements in their policy approval processes, and ombudsman persons and councils based on the various legal frameworks across the continent to represent the interests of ocean users that are here and that are on board. And I think the very definition of sustainable development that we have talked about a very long time in the past is to be able to do this and be able to represent the generations that are not here. So for instance, I'll give a very practical example of trying to create an institutional mechanism for intergenerational oversight. If, for instance, a marine spatial body is established and that has certain guidelines following and stating in its institutional guideline that future generations need to be taken care of or have to be a part of its statement in its operations, we can see that such policies can be reviewed and affect climate resilient ecosystems that affect coral reefs and mangroves, for instance. We also need to inform treaty negotiations and implementation within legal benchmarks. You can use the ITLOS opinion to support regional treaty implementation, particularly when it comes to existing treaties, by affirming that climate and ocean uses already exist under the ITLOS. So what I see happen is that a lot of the time when we are talking about marine, and particularly we're talking about marine life and the UNCLOS and the ITLOS on opinion on international equity, we try and isolate it in one particular space and context. When we can pull up linkages from other parts that are already established in our legal framework to make sure that we can be able to draw from it. Because at the end of the day, interpretation when it comes to legal frameworks and legal policy across the region of Africa, it's important. So being able to pull out and create linkages in existing frameworks that support some of these opinions and still draw from the strength of the ITLOS opinion would be to our advantage. So back to the question that was asked, yes, when it comes to plastic pollutions and related marine life, the partnerships that are necessary, particularly on the continent of Africa, are private sector participation, national and bilateral and multilateral agreements that we have, existing policy and legislative frameworks that can be drawn from, including the international one, such that they are not just statements, but they are legal and implementable things that we can take to court. We like to see that kind of practicality. Involvement of particular state actors that would be able to benefit from it, and then showing how treaties, negotiation, implementation of legal benchmarks that would help, and particularly, and I'll repeat again, the private sector's influence, particularly when it comes to environmental impact assessments, would go a long way to practicalize all the things that we state on the national, regional, and international levels. Back to you, to the moderator. I think I may have overspoken for this one, but that it caught my mind along line here.
So much. That was a wonderfully put answer. So now we have a question for Dr. Justin and Ms. Johanna. So it is mainly because both Dr. Justin and Ms. Johanna have worked closely with governments of small island developing states. So the question is, given the advisory opinions by ICJ and ITLOS, what practical steps can small island states take to translate these legal obligations into enforceable national policies, especially when facing resource and capacity constraints? So if anyone would want to go first.
Joanna?
We can go back and forth as usual, like a team. It's an excellent question, and it can go in many different directions. I think maybe following along the lines of what our previous panelists just said, one of the things that I always discuss when we think about the broader implications of the advisory opinions, particularly when it comes to the International Court of Justice and how if we get this wonderful and hopefully quite progressive advisory opinion out later this summer, we know the certain actors will make statements of things like, oh, it doesn't have enforcement power and all these fancy things. But one of the most important things to come out of this advisory opinion and all of the work that went into the countries that participated, especially from small island states, is we have created the language and the bedrock of much of the litigation that follows from these advisory opinions, including with ITLOS. And I think, the discussion on those environmental impact assessments and the reach that can be had when you're talking about countries that have the powers within their jurisdictions, where there are private actors. It says it in the ITLOS opinion. Private actors are included because if they are doing the impact assessments that do not properly allow for the human rights implications for participation, for actual youth involvement, we have seen where across the world, but even in countries like the United States and whatnot, youth and indigenous communities and local communities are often the ones that are the front lines fighting against and showing how these impact assessments do not meet the standards that exist. That when you're applying the precautionary principle, and we know that risk involved with many of the things, I can even hit another question I saw in there, when we talk about things like deep sea mining, and there are many questions that people like to throw at it, and we're not sure of the impacts and we know the impacts. It's going to be serious, irreversible harm that happens to the marine environments when you're allowed to just no holds barred go in into it. That's not to say we're making arguments against the sovereignty countries have over their own resources, and we know this is quite a political thing. But guess what? Youth and those that are inheriting these problems, we know the history. We know the history of what happens when industries go in and don't have regulations and don't have accountability and remedies that exist for the communities whose frontline issues, their sustenance and feeling one with the ocean and general cultural and traditional practices that can be destroyed because of these things. We have the history and we know these things, and it does require a certain amount of organization of the human rights activists, youth organizing, all of these really impactful and powerful things to stop these kinds of practices from continuing. And so I just say this in order to influence like what has happened in these high level fancy rooms at The Hague and whatnot will be meaningless if we do not, it's not meaningless, but if we do not also continue to take that fight and ensure that the domestic litigation and the fights that are happening are taken in by everyone who is sitting here in these panels and sitting in the audience, so that you're holding your own governments accountable. We've got the language and we've got what's had, and it's going to be really, really important that we continue to take it forward, because that's what matters. Justin, I know please come in and add.
Yeah, thank you, Joanna. And so I saw a recent video with us. Well, it was a sample video, and of us working together as Caribbean and Pacific, and it brought back good memories. I'm sure you know what video I'm talking about. But yeah, that's why I think for small island states, when you're talking about practical steps, that's why I think the issue of reparations for as a legal consequence for a breach of international law by harmful greenhouse gases, knowingly disturbing and destroying or degrading the climate system. That's why I think it's very important in this particular case. Of course, this is what we call high hanging fruit. It's one of the higher objectives that we were trying to achieve. I mean, the jury is still out if any of the judges will speak about it. But if we get one judge, even in a dissenting judgment or in a separate opinion, speaking about that, because you have, and this is not small island states, we're not cap in hand coming out begging. It's not that we're into name calling, but we're just dealing with the facts of the situation. We're just dealing with the injustice, and that's what we said. This is not a negotiating table, the International Court of Justice. This is the International Court of Justice, the highest court in the world. Your duty is not to negotiate the climate. Your duty, like the COP, but your duty is to dispense justice. And when you have countries like Grenada, where 200% of their GDP was wiped out in 2004 by Hurricane Ivan, and then they came Hurricane Beryl exactly 20 years after. And then you have to borrow money to rebuild your economies, to make it more resilient. But that doesn't help, because every year, which is now from June to November, we're going to hear more about it, unfortunately. But between this hurricane season or the cyclone season in the Pacific, it's just a vicious cycle of debt. And who do we borrow money from to rebuild our economies, to become more resilient? We borrow from the United States. We borrow from the UK, United Kingdom. And that is why the Prime Minister of Grenada, the Prime Minister of Antigua and Barbuda, and the Prime Minister of St. Vincent and Grenadines wrote to David Lammy, the Foreign Secretary of the UK, who, by not mere coincidence, is a descendant from Ghana who has Caribbean heritage, saying that, listen, we want immediate debt cancellation, and we want to pay zero interest. Forget all these, because every time a vicious cyclone or hurricane happens, we have to pay for it, right? So how can we really live up to our obligations if we don't have the financial resources to do that? So I think I just want to stop there, but I think that's something that really irks me in a way that shows really the injustice. And it goes back to the whole thing about climate justice being a colonial problem. It's really colonization and just repeating the words of one of my dear colleagues from St. Vincent and the Grenadines. Thank you.
Thank you so much to both the speakers for a very put together answer. So although there is a lot of questions from the participants today, we will not be able to answer all the questions due to the time constraint, and we really apologize for that. And now to ask the last question to Ms. Leah. So we have a question from a participant. So as you have mentioned, the ecocide law movement represents a shift in public perception. However, most carbon dioxide emissions come from private companies and capitalist nations, which in turn arguably reflects public consumption. Then is it necessary that the paradigmatic shift of the ecocide movement is accompanied by a shift in consumption patterns? So if Ms. Leah could kindly answer the question.
Thank you. That's a very big question, so I'll see how I hope I can answer most of it in a very brief, short amount of time. But I think importantly to notice that, yes, a lot of the ecoscience would fall to corporate actors, and that would be about ensuring how do we find how they fit into the framework of an individual actor and who bears the most responsibilities. And clearly there are definitely also legal challenges to that, but I think we have to address some of the big challenges that our legal system faces, particularly when it comes to the piercing the corporate veil that a lot of these decision makers hide behind. So it is about asking complicated questions about how do we have law address this. And yeah, I think particularly within our current world system, we have to also look at, like, we have mass environmental destruction that is happening mostly by actors in the global north, as the question states. And I think something that I think is particularly interesting, why we need this also at an international level, is that there are a lot of some of the criminal cases that have happened historically in the past have sort of been focused on the global south, but this is an opportunity to turn this around and say, well, actually, some of the worst crimes that are happening are not just like actors in the global south, but are actors in the global north, and we have to shift this is in perspective. An opportunity really for the International Criminal Court, the ICC, to shift it around and stand up for the developing states, for the small island states, for the African states, and be like, well, how do we point out the actors that are causing mass destruction harm in the north? So I think it is an opportunity to address some of these historical injustices within our system as well, and to look at how do we address this? And clearly there are big, challenges and big questions for lawyers these days, but I think it's important ones that we have to address within our system. So yeah, thank you. I don't know if I answered everything, but I'll try to. If there's something I forgot to include, please jump in.
Thank you so much, Ms. Leah, for the wonderful answer. So I would like to thank everyone, all the panelists, for answering all the questions from the participants, although we cannot go through all the other questions which is remaining. So with this, I'll now hand over to Mr. Coffey.
Thank you so much, Ms. Lito, and I would like to also take this opportunity to appreciate our speakers and also our participants for their time, because it's their energy and for them being here is what have made this conference, this webinar engaging. We really appreciate your time. Some join us even at late night, and in fact, it's a privilege. I have learned a lot of things because I believe many of the participants are not in this field of OSHI. So when we hear things about OSHI, we usually don't take them into much consideration. But today we have learned a lot of things about it. And as we draw the curtains to this event, I would like to officially once again say thank you to each and every one of you. And I would like to also first of all acknowledge the brain behind the partner group AYLF and also WYC for coming up with these great initiatives. And also this dialogue has truly laid a groundwork for deeper discussion, which will take place in the UN Ocean Conference, where many of the things that we have already discussed here will still be discussed further during the conference. And we will continue to explore it further in the conference, which will happen. And a special thank you to also anybody who made it possible, and to our attendees and also people who participated actively. We want to say thank you for your time, and please note that this is not the end of the discussion, because this is just the beginning of everything. And so whatever you have taken from here, we encourage you to go ahead with it and also draw the lessons from this, continue sharing the message, and ensure that whatever pertains to issues, we can all be a change in this discussion. And I would also like to encourage our participants who did not have the privilege for their questions to be answered, that they can follow us on our social media platforms or on our website to send in their questions, and we will attend to it when we receive them. So please, if your question has not been answered, kindly use our social media platforms to reach out to us or visit any of our websites, and we will attend to your question. So a special thank you to each and everyone once again, and we appreciate your time, and we wish you the very best for the rest of the day. Have a great time and wherever you are. Thank you.
Thank you very much.
Thank you very much for having us. It
Thank
was a
you.
great discussion.
Thank you
Definitely.
so
Bye.
much.
Thank you. Bye.
Take care, everyone.
Bye. Bye.